Tom Abbate, and today I'm going to talk to you about sex crimes under Texas law. You will note that we've had a previous video regarding the defense of sex crimes. This is things regarding what you should be looking for in a lawyer, things of that nature. A link to that video will be down in the comments of this video in case you prefer to look at that one as well. Now, regarding the actual sex crimes, we've got different tiers under Texas law. They're all felonies, so they all carry at least some punishment range where there's the potential for incarceration. The other thing that you need to keep in mind is that they all have some level of sex offender registration post-conviction. Now, in Texas, regarding these kinds of crimes, and I'm going to focus on just the ones that will cause you to have to register. There are other offenses of a sexual nature, but today we're going to talk about just the sex crimes. These begin at indecency and go all the way up to continuous sexual abuse. Now, indecency with a child, you've got two different types. You've got by exposure and by contact. By exposure is a third-degree felony. It has a punishment range of 2 to 10 years if convicted, with a mandatory 10-year registration requirement post-conviction. Now, indecency by exposure is the allegation that the defendant removed the child's clothing for a sexual purpose. Not that he touched the child, not that they did anything to the child beyond removing the clothing. Okay? You also have indecency by contact. That is where not only has someone removed the clothing or reached under the clothing or on top of the clothing, but has touched part of the genitalia of the child, whether that be the vagina, penis, breasts, butt, any of those things. It can be over the clothes touching or under the clothes touching. That can satisfy that. That is a second-degree felony. It carries a punishment range of 2 to 20. Additionally, kind of lumped in here is sexual performance of a child. This is somewhat akin to indecency by contact or by exposure, but not quite to the level of indecency by contact. This is where the child has been videoed or displayed in a lewd or inappropriate manner. And, you know, this will also cause, if convicted, this will also cause a registration requirement. It fits in between the two, and so the punishment is not as egregious as a second-degree felony, but there are some little caveats in here, so we'll save that one for a different date to go into the actual details of it. Above indecency by contact, you then start moving into actual sexual assault. Now, sexual assault is any time that the defendant's genitalia penetrates the complainant's genitalia. For instance, and it can also go beyond that too. For instance, the penetration of the penis into the vagina is enough to get to sexual assault. The contact of the penis to the vagina is also enough to get to sexual assault. So there's a couple of different ways that the state can get there. But with regards to children, if the complainant is over the age of 14, then it will be a regular sexual assault, meaning that it's a second-degree felony, 2 to 20, okay, with lifetime registration. If the child is under 14 years of age, then it becomes a first-degree felony, with, 5 to 99 being the punishment range and a lifetime registration. Additionally, if the complainant is shown to be less than 6 years of age, it's still a first-degree felony, but it has a minimum sentence of 25 years going all the way up to life, and the availability of parole is removed, in addition to a lifetime registration. So, for instance, if the child is extremely young, When the jury goes, if they, having found the defendant guilty, when they go to assess the punishment, they start at 25 years. And without the availability of parole, that means that if they only give 25 years, that defendant will do every single day of those 25 years before being released. Now, the highest offense in this category is continuous sexual abuse. And this is a very, very difficult offense to deal with, because typically what the allegation is that it is 2 or more instances of lower level offenses having occurred over the course of a 30-day period or more. So what you're looking at is anytime the defendant is alleged to have repeatedly sexually assaulted or indecently contacted the complainant. It can also cover more than one complainant at a time. This is a very, very broad statute, and it covers a lot of different conduct. This one also comes with a punishment range of 25 to life, no parole. And it can be very difficult to deal with because the state, under the law as it is currently written, only has to list out multiple different possible instances of abuse. The jury does not have to specifically agree on any 2 of them. They just have to agree that 2 on that list occurred, even if all 12 of them came to 2 different ones. So long as they all agreed that there are at least 2 instances of some kind of, sexual indiscretion with a child on that list, then they can convict the defendant. There are some double jeopardy issues regarding this, which we won't really deal with here, but just understand that these kinds of cases are very difficult to defend. You really need to spend a lot of time working up the facts and circumstances to figure out where they can be attacked. You also need to be very much prepared for the punishment phase, even if you don't get there. The reason being is that if you do get to that punishment phase, the defendant is looking at a substantial amount of time, typically. And so anything that you can do to humanize the defendant and show that this is not everything about that defendant, the better off that defendant will be when and if that jury determines what sentence is appropriate. The other thing to keep in mind with any kind of sexual assault or sexual indecency charge regarding a child is that the state of Texas has gone to great lengths to make sure that that child's testimony is presented in the most efficient manner possible. There is nowhere else or no other charge that I'm aware of where another witness can come in and testify as to what the complainant told them. Usually that's, kept out under a hearsay objection, but at least when we're dealing with children under the age of 14, the outcry statute allows any adult witness over the age of 18 who was the first person that this child disclosed this allegation to in some discernible manner, they get to come in and testify as to what they were told. Okay. Additionally, the sexual assault nurse examiner is going to just basically look over and take down the complainant's testimony. There may or may not be any physical evidence located, depending on how delayed this outcry was. But for medical purposes, it will be written down. Her allegation will be written down, and it will be testified to in court. So it's very important that you research the case and you know how to attack the credibility of these witnesses in an appropriate manner, because the state of Texas has set the rules so that it is much easier to get these kinds of convictions than it might be for something like a murder.